Hi, hello world, internet, all of you lot. Gosh, it feels like a long time since I've done this, so let's see if I can remember how to do it. Let's also see if I can get it within 15 minutes this time. The last time I had a pop, I overran. So let's talk about the Human Rights Act. Now, what's the most important thing to say about the Human Rights Act? First of all, that it is an act of Parliament, that it is statute law. It is part of the British Constitution insofar as it is a law passed by Parliament and enforceable in the courts of the UK. Now, before we get on to that, let's have a little bit of historical context. Now, the European Convention on Human Rights has existed since 1950, and this is a common set of rights that all signatories have to recognise. And there's a special court, the ECHR, rather annoyingly, to uphold the ECHR. The principal idea here is that the UK was instrumental not only in the drafting of the ECHR, but also in seeing it ratified. We were one of the first signatories in 1951. And it's hard really to see how the UK can remain in the EU and not be a signatory of the ECHR. So in other words, if we want to derogate from the ECHR, we would probably have to leave the EU. There's only one non-signatory in the EU, and that's Belarus. We're not Belarus, so we don't need to know. I suppose the interesting thing is that Russia is also a signatory of the ECHR, in spite of the fact that it is not a member of the EU. But I'm going into weeds, and I don't really want to do that. Particularly not as time is a factor here. So let's just push on. The ECHR is binding. It's not part of the EU. Okay, it is instead an entirely separate thing, and it is expected of all of those EU members, and it's here. Strasbourg is about here, so the court is in Strasbourg. There it is. It's coming out, and now let's just move it over there. So what happens is, if you feel that your rights, as described by the ECHR, have been abused, even if you are British, then you would have taken your case to Strasbourg. Now, that was the old model, and the old model was a bit of an embarrassment because people in the UK kept taking their cases to Strasbourg, and the government kept losing because we're a serial abuser of human rights. And as a result of that, the Blair administration in 1998 said, okay, well, let's sort this out. Let's start washing our linen at home. So they took the European Convention on Human Rights, they took a photocopy of it, they scratched that bit out, and they changed the background, and lo and behold, this is what we got. We get the Human Rights Act of 1998, which is, to all intents and purposes, exactly the same with a different title. So we lose the ECHR, we call it the Human Rights Act, and we're happy, and it sailed through Parliament, and everyone was pretty pleased with that, to be absolutely honest. Now, what does this mean? It means that rather than having to take your case to Strasbourg and argue it in front of the European Court of Human Rights, that European Convention on Human Rights, albeit under a different name, is now justiciable in the UK. In other words, you can take your case to the UK courts instead of dragging it all the way over to Strasbourg. We also have a greater sense of clarity. We have a clearer set of rights that we can expect, and that means that with that is a clearer set of obligations on the state and indeed of other citizens. With every right comes an obligation. If I have the right to freedom of speech, you have an obligation to let me speak. You don't have to listen, but you can't stop me talking. Just doing it again in a slightly different way. As I said, now the ECHR is justiciable in the UK courts. And not just that, but there is a statutory obligation on public authorities to comply with the rules. This is a new set of rules that now applies on public authorities, be that the government, be that Parliament, be that councils, be that schools, whatever it is. All public authorities have to comply with the terms of the ECHR. All private citizens need to abide by the terms of the Human Rights Act. There's also an obligation on Parliament to draft laws so that they can fit in with the ECHR. We still have to abide by the ECHR. The Human Rights Act, because it's an act of Parliament, we can kind of tinker with, but we still have to try to abide by the ECHR. And that goes with the courts as well. There's an obligation on the courts to interpret legislation, we know that. But the interesting thing here is that if there's any sort of benefit of the doubt, if there's any way in which the courts can look at parliamentary legislation and interpret it in such a way that it is compatible with the ECHR, then the parliamentary legislation should get the benefit of the doubt. It should be allowed to pass. If it's not, then we have a declaration of incompatibility. That legislation goes back to Parliament, because of course only Parliament can muck around with statute law, and usually they will amend it or repeal it and produce something else that is compatible with the Human Rights Act / ECHR. Now, there are numerous problems that we can associate with the Human Rights Act. The first of these is mission creep. This is the idea that it's part of either the expansion of the EU into day-to-day life in the UK, or indeed part of the expansion of the courts into the domain of the politicians. There's also the idea that this leads to the exploitation of rights by criminals and bad men, and that what we're seeing here is the government, the society getting its values wrong. We're valuing individual rights ahead of community rights to things like safety and security. Why can't we just deport that man? Why should we be allowed here because of this, that, or the next thing? And so, yes, the individual right to whatever, trumping community rights to security and safety. It's also argued that it undermines the autonomy of the courts, because the courts, it is said, have to follow ECHR direction. And at the same time, it's argued that it undermines parliamentary sovereignty, because Parliament now has to try to frame its legislation so that it's compatible with the ECHR. Now, each of these can be challenged, and we're going to go through them in order. The first of these, mission creep. Well, let's have a look at that. The first point to make is that the ECHR has nothing to do with the EU. The ECHR is an entirely separate entity. It has nothing to do with the EU. It is all to do with the European Court of Human Rights. It is not EU law. It is nothing along those things. It is a separate treaty that members have signed. Now, it is understood that membership of the EU is generally going to be predicated on signing up to the ECHR, but it's not essential, as we've described with Belarus. But it does require some extraordinary terms before you can extricate yourself from it. It may be that the British may want to go down that route. But the key point is this has got only vicarious relation with the EU. Furthermore, this is a law that Parliament passed. They took this law and they said, no, we want this. We want this law. We want to have it in our portfolio of laws. We want to have it in our constitution. So I'm afraid, caveat emptor, you knew this was coming. And of course, the last point to make here, and sort of alluded to this earlier, is that whether we are a member of, whether we have the Human Rights Act or not, we are still bound by the ECHR. The ECHR is above all of this, and we signed up to that in 1951. And until such times as we unsign that, then we will be bound by the ECHR. Now then, what about this exploitation of rights by criminals? Well, I suppose the key point to make here is this. It's essentially the rule of law. It's not so much that criminals are exploiting the loopholes in the law as they are that we are extending the rights to them that they would normally enjoy as a human being. Now, the extent to which we start taking rights away from people is important. It's part of the social contract. But generally speaking, if there's some sort of unalienable human right, then that should apply to people whether they're criminals or they're not criminals. So again, what we're seeing here is all laws apply to all peoples. And there's the sort of attendant point to that is people talk about social rights to security. Well, there is no such thing as a social right to security. There is no such thing as a community right to safety. That's just not true. In liberal jurisdictions, it's all about individual rights. And so our laws are framed in terms of individual rights. If you want to go and live in somewhere with collective rights to security, prosperity, and so on, that's communism. So by all means, go and do that. The principal point, again, I'm repeating myself, I do apologize for that, is that any liberal jurisdiction will be framed in terms of individual rights rather than community rights. As soon as you open the door to community rights, then you start treating people as means to ends. If they're enemies to community, you just, get rid of them. And again, yeah, that's communism. The other point here that's worth mentioning is that the egregious exploitations that we read about in the Daily Mail and Telegraph and so on tend to be a misrepresentation of fact or an exaggeration of fact. And so when you drill into them, they tend to be much less egregious or devastating than you might at first have thought. Again, a little reading around the subject will demonstrate exactly what I mean by that. Now let's look at the next one, which is the idea that it undermines the integrity of the courts. Well, that's not true. In fact, that's very far from the truth. The courts are not required to follow the ECHR. They should simply take them into account. But the important thing here, and the really interesting thing here, is if disagreements arise, it's not like the UK courts have to run up the white flag and say, okay, well, we have to bow to the demands of the ECHR. That's not true. If a disagreement arises, both sides have to consider their positions. And so it's entirely possible that the ECHR will look at it and say, we'll look at an issue as it arises, and rather than demand compliance from the UK courts, they will say, well, you know, maybe they've got a point here, maybe we're being dogmatic, maybe we're exaggerating, whatever it is. But the UK courts can actually influence the ECHR as much as the ECHR can influence the UK courts, and that's interesting. And then finally, we've got this one. It undermines parliamentary sovereignty. Well, I mean, I offer you this one here. The Parliament knew exactly what they were signing up to back in 1998. But again, and that is, you know, rather what maybe being a member of a club is about. But it actually enhances parliamentary sovereignty because previously disputes under the ECHR would have gone straight to Strasbourg. And Strasbourg has very little interest in trying to be nice to Parliament. However, what we've got here is this idea that the courts, remember from the previous slide, are obliged to try to uphold parliamentary legislation. And so what we've got is that sense in which the courts are much more likely to uphold UK legislation than a Strasbourg court. If it goes to Strasbourg, they're just going to kick it straight out. So, yeah, not much to be gained there. And complicated point. I'm running through it very, very quickly because I've only got 3.5 minutes left. Questions on that, we will have to defer to class. Now, I just want to talk to the Anti-Terrorism Crime and Security Act here. The key point, couple of points I really want to make here is that, first of all, in passing, the Anti-Terrorism Crime and Security Act, the Human Rights Act was amended. The Human Rights Act was amended so this could pass through, but of course, in amending that, they could not change the ECHR. And when the courts came to look at it, they said, well, actually, this is incompatible with the ECHR, blah, 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 blah. The derogation from the Human Rights Act was not permitted, not justified, and so they issued a declaration of incompatibility, and these people needed to be released. Now, the usual arguments that come up with reform of the ECHR can be challenged on the following grounds. What exactly is it going to say? Is it going to be toothless? Is it going to be profound? In which case, well, we've kind of got one that does that already. How is it going to be entrenched? Well, it's legislation. It can't be entrenched. You know, so why do you want to change it? And finally, what will be the relationship between the UK and the ECHR with a Bill of Rights? Well, we're still signatories of the ECHR. In other words, the whole notion of a European or a British Bill of Rights is nonsense on stilts. Don't get dragged into it, but be in a position where you can dismantle that particular argument. Now, what I will say in closing is that we've had the Human Rights Act. This was passed in 1998. Since then, we have had the Terrorism Act of 2000. You can read that. That allows people to be detained for 48 hours. We then had the Anti-Terrorism Crime and Security Act, which I discussed earlier. That has since been repealed. And it has been replaced instead with the Criminal Justice Act, which has extended the detention window to 14 days. We've got 48 hours there, and we've got 14 days on the next one. We've then got the Prevention of Terrorism Act in 2005. This replaced the Anti-Terrorism Crime and Security Act, which was declared incompatible in 2004. And so we had this one come in instead. Yeah, not many people liked it, to be absolutely honest. But we do have these control orders which replaced, control orders, I suppose, better than indefinite determinant without trial. Very interesting little exchange there. It went on and on and on until the early hours, and I'm going on and on and on, so I'm going to move on. We've now got the Serious Organised Crime Police Act. Those of you who've seen Taking Liberties will know all about this and the exclusion zone around Parliament when it comes to protest. We've also got the Terrorism Act of 2006. We're now up to 28 days. Interestingly, Blair wanted 90 days, but they said, no, you're not going to have that. And so instead we settled at 28 days. Counter-Terrorism Act, this time they said we wanted 42 days. And the court said, and Parliament said, no, we're not giving you that. And so we're still at 28 days. Counter-Terrorism Crime and Security Act, this came through after the coalition was deemed unnecessary, and it's making an absolute hell for teachers who have to do a lot of paperwork. And this is the regulation of Investigatory Powers Act, which is still going through. It's a joke. not a very funny one. And that's it. What I will point you towards now are a series of resources. None of these are easy, okay? There's no point being easy. It's not an easy subject. But if you follow these resources, they are all hot linked on StoneNet. You should be able to find them. And that's it. I'm timed out. I'll speak to you soon. Bye.